Fast pursuit. They've been chasing that van right there. Now
he is. It's exactly what he's doing. Are you Googling the laws right now?
Henderson Police Department's SWAT team responded to the scene and set up a perimeter around the condominium.
I can travel in and out of time zones.
And the 3 key rules for a criminal defense lawyer: always on time, impeccably dressed, and occasionally sober.
The yellow sports car up ahead won't stop. Then, something happens you might expect in a Spider-Man movie. It wraps around the tire of the fleeing vehicle and stops all forward motion.
Objection, asked and answered.
I mean, he leaps over the fucking bench.
No, the thing is, that's my property. You have no choice.
Actually, I do, because I found friggin' Xanax bars on your driver's seat. If you want to explain something, explain those.
Cops get very frustrated when you don't answer the questions.
No.
step back forward.
He's gonna go straight. There's a car right here. Got him.
All right, I'm going to excuse everyone. Mr. Brooks is being removed from the courtroom.
This is fucking hilarious. So he pulls out a joint in court.
Go, 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 go.
Turn on your stomach! Stop fighting us! Stop resisting!
The injury by the police, that may be a separate issue for you to file a civil suit.
Chris, just while he's doing that, talk to me. What were you running for again?
Warrant?
Warrant? The felony warrant, city warrants what?
Felony warrant on Kansas.
Well, I'm pretty sure they ran you, and you don't have any warrants.
I don't.
No.
No warrants.
No.
Oh, there's my Kelly.
It's all that for nothing, right? No warrants, no nothing.
Yeah.
Police!
A little farther, but a little more. Okay, go.
I'm not finna sit here and let you fix the trial because you don't want to tell the truth to the jury.
We're there, guys. Got eyes on.
I want to suck it. Yes, I think I would like to suck your dick. I don't think so.
I prefer not to.
I prefer not to, sir. See that? I love that.
So do you wish to say anything?
No, ma'am.
All right, thank you.
Well, hello. Welcome back. I'm Jody, and this is The Defense Rests. And we are here today for a more conclusive update on 2 important people in the true crime world. First one being Darrell Brooks. He currently has just had another hearing on charges that he's facing for a few weeks prior to the Walkinshaw Parade massacre, where he's alleged to have run over his ex-girlfriend and mother of his children, Erica Patterson. He's also facing charges of intimidating a victim, witness intimidation, and bail jumping. So we will lead with that one first. But secondly, we're also going to catch up with some more information on the Ty Tucker arrest. He was arrested in Oregon on his way back to the Florida Keys a day or so ago. And my last live stream explained a little bit about it. It was very bitsy. I apologise. But I'm actually going to get it from almost the horse's mouth today. Justice is a Process has given me his permission to use his live stream feed, and he explains it way better than I can. So we're going to go through his feed, and I will add my little tidbits as we go through. So exciting evening planned. And I'm also planning, I'm in the process of doing a deep dive on the Franklin Tyrone Tucker case and putting together a whole video of just the evidentiary process and how we got to where we are right now, pretty much. Now, Tyrone's free Tyrone Tucker Facebook page. Apparently, Lauren isn't able to post any updates on that page at the moment. Facebook won't allow her to. They may have frozen it for some reason. But she is able to post updates on to her personal page, which I have her update on that. So stay tuned. And welcome. And thank you for joining us. So we'll get into the Darrell Brooks hearing that was on last evening. See what they have to say.
Hello, Your Honor.
We are here. It is the day that our trial was scheduled, but I have plea paperwork, and I understand that the parties have reached an agreement. Mr. Torbenson, do you want to put the state's offer on the record?
Case ending 4-5-9-6. The state anticipates Mr. Brooks entering a no contest plea to count 3, second-degree recklessly endangering safety as an act of domestic abuse. Based upon that plea to count 3, the remaining charges would be dismissed and read in for consideration at sentencing. As to case ending 5-0-2-0, the state anticipates Mr. Brooks entering a plea of no contest to count 1, felony intimidation of a victim. Based upon that plea, the state would move the court to dismiss and read in the remaining 2 charges for consideration of sentencing. At the time of sentencing, the state will recommend that the court sentence Mr. Brooks to a substantial term in the Wisconsin state prison system. We would leave the ultimate interpretation of that to the sound discretion of the court. The defense would be completely free to argue.
Just as an update, so this is a hearing for a separate incident completely to the Waukesha Parade massacre. But Darrell Brooks is facing, he's already serving 6 life sentences and 762 years in prison, as well as an additional 2 years for possessing a firearm as a convicted felon. So this is a hearing for, as I said, Erica Patterson, where he was allegedly ran her over, and the injuries she sustained from that. And he has actually, at the last minute, taken a plea deal. So we shall hear the information and details on that.
You for the appropriate sentence.
It also contemplates the amended information's not being filed.
Okay. Mr. Torbenson, you talked about count 3 as charged, correct?
Yes.
Okay. All right. Mr. Jones, is that your understanding of the state's offer?
Yes, Your Honor, and I actually did an attachment of an email string between the state and I for clarity of the record.
Okay, I appreciate that. And
I had Mr. Brooks' initial next to the offer section.
Great. You're planning or anticipating that it will be a no contest plea. Do you want to make a record as to why that is rather than a guilty plea?
Yes, Your Honor. My client is entering a no contest plea. In those discussions, I indicated that he understands that he'll be found guilty, but he is standing silent as to, he's not contesting the allegations because of potential civil liability, which he may or may not be exposed to with respect to these charges, and therefore we've negotiated a no contest plea. But I will tell you that he understands he'll be found guilty. This is not a maintaining of innocence thing. This has an issue. This is a legal decision based upon potential civil liability.
All right. And the state that was part of your offer, and you are willing to accept a no contest plea for those purposes?
I am understanding that the victim, Ms. Patterson, can still seek restitution in these matters if she so wishes. We are not objecting.
All right. All right. And the court is willing to accept it for the reasons that have been stated on the record. The named victim will have the opportunity to put in a request for restitution that is separate from a civil liability thing. It's so that will still be a potential that will be part of this. So, Mr. Brooks, it is my understanding that you are planning to enter a guilty plea today to
no contest.
See, I told you I would do it.
I know you did.
It is habit. I apologize. A no contest plea to 2 of these charges that are pending against you. Is that correct?
Yes, Your Honor.
All right. Have you had any drugs or alcohol in the past 24 hours?
No, Your Honor.
Are you on any medications?
No, Your Honor.
Are there any medications you're supposed to be taking that you have not taken?
No, Your Honor.
All right. You've been charged with a number of counts in each of these cases. It's my understanding that you're going to enter a guilty plea to the two. Or sorry, I said did it again. No contest plea to the two, and then the other charges will be dismissed and read in. What that means is, for the dismissed and read in counts, you will not face any penalty for those, nor will you have a conviction for them. However, when we get to sentencing, the state will make their argument as to the facts of the case, and they can argue the facts that relate to those dismissed and read in charges. And I can take those into consideration when I sentence you on the two that you entered the no contest plea to and that you were ultimately found guilty of. Do you understand that?
Yes, Your Honor.
All right. So for the two that you are going to enter the no contest plea on, the first is a second-degree recklessly endangering safety with a domestic abuse assessment. That means that it is a Class G felony, and for that you face the potential penalty of a fine of up to $25,000 and imprisonment of not more than 10 years or both. That 10 years is broken down into two parts. 5 years initial confinement and 5 years extended supervision as a maximum. Do you understand that's what you're facing?
Yes, Your Honor.
In addition to that, because of the nature of the crime, that this is someone that you have been involved in a domestic relationship with, or either resided with, or have a child with, you would face the domestic abuse assessment for that, which is just an additional $100 penalty that would apply against you, as well as a federal ban on ever possessing a firearm. Do you understand that?
Yes, Your Honor.
All right. And then on the count one, felony intimidation of a victim, that you're going to enter the no contest plea on in case 21 CF 5020. That is also a Class G felony, potential penalty of a fine of up to $25,000 and imprisonment of not more than 10 years, or both, broken into that 5 years initial confinement and 5 years extended supervision piece. Do you understand that?
Yes, Your Honor.
You also understand that if you were to be sentenced to prison, you would have to serve in.
I'm not surprised he's taken a plea deal. I mean, he's facing 6 life sentences, 762 years in jail without parole. What's another couple of years, really?
Prison each day imposed as initial confinement, because initial confinement time is not reduced by good time or by parole.
Yes, Your Honor.
You further understand that when we get to sentencing, I was not part of any negotiations, so I'm not bound by anybody's offer or recommendation. I will listen to what the state has to say, anything that the alleged victim has to say, either in writing or in person or in, I guess, any other form. Anything that your attorney says, anything that you say, and anyone who speaks on your behalf. I will take all of those things into consideration, and then I'll sentence you as I see fit, which could be up to and including the maximum penalty. Do you understand that?
Yes, Your Honor.
Do you also understand that because these charges are felonies, once you are convicted, there's some additional consequences, including the fact that you will never be allowed to possess a firearm at any time in the future. You may not vote in any election until your civil rights are restored. You will have to provide a DNA specimen to the Wisconsin State Crime Lab for DNA testing. And because these are violent felonies as defined under Wisconsin law, you may never possess body armor at any time in the future. Do you understand that?
Yes, Your Honor.
Do you also understand that if you are not a citizen of the United States of America, the plea of guilty or no contest for this offense with which you were charged may result in deportation, the exclusion from admission of this country, or the denial of naturalization under federal law? Do you understand that?
Yes, Your Honor.
Do you further understand that if you enter a no contest plea, you will be giving up all the same rights as if you had pled guilty? And at the end of this, even if you enter a no contest plea, I will find you guilty of these crimes. Do you understand that?
Yes, Your Honor.
All right. So what is your plea then in 21 CF 4596 of second degree recklessly endangering safety with the domestic abuse assessment?
No contest.
No contest, Your Honor.
All right. And in 21 CF 5020, intimidation, felony intimidation of a victim.
No contest.
No contest, Your Honor.
All right. Now I have in front of me your plea questionnaire and waiver of rights form. Did you go over that with Mr. Jones and sign off on it today?
Yes, I did, Your Honor.
Do you understand that when you say no contest, rather than asking for a trial, you give up a number of constitutional rights that are guaranteed to you? Those
I think
include
they've
your
already
right to
gone,
remain
those ones,
silent
which
and
is
not
all right.
incriminate yourself,
He's
the right to see
incarcerated.
and cross-examine the state's witnesses as well as call witnesses on your own behalf and have them come to court to testify for you, the right to actually have a trial, which could be a jury trial where 12 people sit
Lord.
together, listen to the evidence, and then must agree as to each element prior to reaching a decision, or a court trial where the judge listens to the evidence and makes a decision. And finally, the right to make the state prove you guilty by evidence beyond a
I don't think
reasonable
anyone
doubt
can
that you
sit
committed
through
the
another
crimes
Darrell
charged.
Brooks
You
trial just
understand you give
quietly.
up all those rights when you say no
My opinion.
contest rather than asking for a trial.
Yes, Your Honor.
You also realize you're giving up the right to raise any motions, such as suppression of the evidence, identification of you as the person who committed the crime, suppression of any statement you may have made, or any challenges to the information or the complaint?
Yes, Your Honor.
Do you also realize you're giving up the right to raise certain defenses you might have, such as insanity, self-defense, intoxication, alibi, coercion, and necessity?
Yes, Your Honor.
Did anyone make any threats or promises to get you to enter into these pleas today?
No, Your Honor.
Did you read and understand the criminal complaints that were filed in these cases?
Yes, Your Honor.
And did you discuss with your
Is
attorney
that
the elements of
lawful
these
law?
offenses?
Yes, I did, Your Honor.
Do you understand that if we had a trial, the state would have to prove as to the second-degree recklessly endangering safety that on November 2nd, 2021, at 7311 West Capitol Drive, that you endangered the safety of another human being, that you endangered the safety of another by criminally reckless conduct. That criminally reckless conduct means that the conduct created the risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and you were aware that your conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means serious bodily injury, injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury is great bodily harm. Do you understand that's what they would have to prove at trial if we had a trial in this matter?
Yes, Your Honor.
And you understand that by pleading no contest, you are admitting that you believe that the state has adequate evidence upon which they could convict you, and you are opting not to challenge that evidence. Is that correct?
Yes, Your Honor.
All right.
His counsel
As
is so
to
excited he's playing on his
count
phone.
1 in 21 CF 5020, do you understand that's the felony intimidation of a victim?
Gonna be
That
home
if we
early.
had a trial on
Yep,
that matter,
yep.
the state would have to prove
He took a plea
that
deal.
between November 5th, 2021 and
roast on.
November 15th of 2021, from 949 North 9th Street, that, what are the initials? EP?
Yes.
EAP, was the victim of a crime, that you prevented, dissuaded, attempted to prevent, or attempted to dissuade EAP from reporting the crime to any law enforcement agency, and that you acted knowingly and maliciously. Do you understand that's what they'd have? The state moving to dismiss and read in the 21 CF 4596 counts 1, 2, 4, and 5.
Yes, and counts 2 and 3 on.
As well as EAP. If you would like to have a friend or a relative speak on your behalf, I'm more than happy to talk to that person. If there's more than one person who wants to do that, they should put their comments in writing and get them to Mr. Jones so he can electronically file them at least 3 days prior to that sentencing. If there are issues of restitution,
going through another
that will be determined at sentencing if possible. Is there a request for a pre-sentence investigation?
Okay, so let's get out of there. The sentencing hearing, that's right, I looked it up today, is the 17th of June, I believe, but I will keep you updated on that. So we'll stop sharing that, and we shall get into the juicy bits. Let me share screen with none other. Let's get out of here. Then the infamous, should need no introduction, Stephen from Justice is a Process.
Don't forget to put the bins out.
And right there goes my Google Nest reminding me to put the bins out. All right, now this is hello, Reverend Beasy. Welcome to the defense rest. Thank you. On the one hand, I'm happy he pleaded for the sakes of those. Oh, on the other hand, that was disappointing. It was August 17th. Oh, was it? Okay, I'll double check that. But 17 comes in there somewhere, no doubt. Yes, for Erica's sake, she probably would have liked a little bit more closure than that, but it's over. Well, as far as the pleadings go, as far as her mental health and ongoing well-being, not so sure that's probably going to be lifelong. Having watched the Waukesha parade trial, nasty, horrible, devastating, and he certainly got what he deserved. Now, that's my opinion. So we're on to the second half, which is the update on Ty Tucker, who has been taken into custody. Now, this is, as I said, Stephen from Justice is a Process. I will put up his information on, where is it? So this is his YouTube page. So I recommend that you go and like and subscribe his page. He is like an encyclopedia on this case, and his YouTube channel is not monetized at the moment. YouTube has, in their infinite wisdom, taken his monetization off him. So he's offering these 3 ways in which you can support his channel. So do head over to Justice is a Process, and we will be watching his explanation on what's going on, because he's in contact, or he has been in contact with Ty regularly on his channel, both as an interview and in chat, as well as Lauren as well. And Lauren does come into the chat to speak with him further on into this video that he put out yesterday, and they're waiting at the moment. He's being held in, I can't say that the name of the place. It starts with M, but it's in Portland, Oregon. Basically, what has happened in the lead up, I'll let Stephen explain it. He does a way better job than I do. Trust me, if you watch my last live stream, you'll understand. All right, take it away, Stephen.
I apologize for the sound issues. So anyways, let's talk. Let's get caught up now. So what I was saying was, the last time we talked, Ty was in chat. We were chatting, and Ty was going to be turning himself in. He was planning to turn himself in. He was going to fly down to Key West and turn himself in, and he was waiting to file some motions and get with the judge. Essentially what occurred, and again, we're going to, the chain of events, Ty unfortunately misunderstood how this was supposed to work. He was supposed to get with his bondsman, so the bondsman could escort him back and ensure that what happened didn't happen. He, through a series of unfortunate events, thought the bondsman was a previous bondsman that was reaching out. He contacted the judge and told the judge's office, I'm coming. I'm going to be getting on a plane. Obviously, the judge here, who isn't trying to do Ty any favors, didn't do anything to prevent what was going to occur here in this when he goes through the airport and they check him. He was also supposed to stay on pretrial services. In other words, the bondsman's supposed to coordinate with pretrial services because he's on a monitor. So when he left the house, immediately comes up, and I believe probably it alerted them, and a fugitive warrant got issued, and he eventually gets picked up at the airport because they're aware he's outside of where he's supposed to be, which doesn't take a whole lot of a long time, and the fact that there was already an arrest warrant issued. And as a result, they came and picked him up at the gate, and now he's in jail, and now he's going to have to be transported however they decide. He could be transported by bus, but I think someone's going to come down and probably pick him up. But the bottom line is he's going to be transported by somebody from the Monroe County Sheriff's Office, which is a little concerning because I kind of think that's what they wanted all along, because as they're transporting him, they're going to be able to say, hey, we were with Ty Tucker. We were able to hear what he said, and they will be able to recount any type of incriminating things. And that to me is the biggest concern, is they're going to be able to say whatever conversation they want to say happened. Happened. And
that would be hearsay, though, wouldn't it? They'd have to have it recorded, and they'd have to have read him his Miranda rights prior to being able to submit anything like that as evidence. Is that? I'm not really sure about that, but if you know, let me know. Oh, come on, play.
And with these guys, I would not put it past them to say, hey, Ty said something incriminating. Ty said this, Ty said that. The other thing that's going to come into effect is because he left pretrial detention, it's going to make it all but impossible for him to ever get a chance to get back on bond again, because he didn't.
Stay tuned, Reverend Beasy, because it's not all as it seems. Just saying.
Follow the procedures. And I think that's what the judge is trying to get at here with him, is he's late for court. He's been late for the last 2 Zoom hearings. He's not following his procedures. And he's, just constantly late and constantly pushing things. But I don't think bond should have been revoked. I think they were looking for a reason to revoke bond. So I think if you're Ty in this instance, you got to live perfect. You got to live perfect. You can't let them get this opportunity on you, because I believe, as I laid out in the last live, this judge is not a friend of Ty's. This judge will not be dismissing this case. There is no chance that he will dismiss the case, period. I don't believe it at all, because as I laid out, he was appointed by unfortunately, he was, yes. He discussed that, and the judge at the beginning of all the Zoom hearings would say Ty kept saying that he would get the wrong. He had the wrong court. He had the wrong link, and the judge at the last Zoom hearing was like, "Mr. Tucker, I've had the same Zoom link for like the last 3 years, so I don't know what's going on. I don't know why you're having this issue, but the next time you need to be here early." And then he had warned him about.
Now, if you remember, if you've watched the first trial in January, where it was a hung jury, he was late very frequently and was constantly being reprimanded for that. Then he's had 2 status hearings in April for this upcoming trial on via Zoom, because obviously the judge is in Florida Keys or Key West, and Ty lives in Oregon under house arrest on an ankle monitor. And so they were conducted via Zoom. And there is another upcoming hearing to go through all the motions that have been submitted. So, the 2 status hearings that he had via Zoom with the new judge, Judge Morgan, he was late too via Zoom as well. Now, just clarifying with the pretrial services testing that he was supposed to have, he was late for that too. And the registration, there must be some form of time frame on the date that you're due to have your testing done that cuts you off. As soon as that time frame is gone, then you can't register to have your test submitted. So he was late for that and missed it. And as explained, he was told to come back the following morning early so that he didn't miss the next one, and unfortunately he was late for that one as well. So that is and the Judge Morgan has, he's an ex-military background, so he's all about procedure and making sure that everything's done as per protocol. So he's probably going to be more strict in that regards, but he's not letting him get away with anything. And 3.1 million in bond for a missed, alcohol screen, when alcohol has never even been an issue in this case from the get-go, especially right on the heels of, the motion to resubmit the gag order. It's just it just smells to me.
He'd equally warned him about the fact that he had let his ankle monitor, the battery died, even though he's got problems with it. But he said, listen, you are still on monitoring. You are still responsible to make sure these things happen. So, the thing was that the judge was telegraphing that he was going to do this. He had even told him at the end of one of the hearings, there's a warrant on my desk. The ink is dry, but I decided not to file it in. I just decided to warn you that any more problems, any more missed appointments, anything at all, I'm revoking you. And obviously,
so he was warned.
That's what he did. Now, Ty was under the impression that this judge was going to be a friendly guy, a fair guy, that he was coming to him with all the potential for to conflict him out, because, well, that just shows what an honest guy is. That wasn't my read of him. This guy was telling him, listen, I'm here to make sure you do things correctly. I'm here to make sure things are done procedurally. And I'm here to ensure that you waive everything you're supposed to waive, so that when appeal comes down, you can't say, I didn't know this, I didn't do this, I got railroaded. And on top of that, because he's a new judge, because he's the newest.
Just in saying that, whilst yes, he may well have been late, and his timekeeping skills are less than perfect, that still doesn't make him guilty of doing what he's been accused of doing. Just saying.
This judge, the guys down there feel like, hey, no one's going to say this is a Bubba guy. That's exactly right, Flash Fan 85. No one's going to say this new judge is Bubba. He's not part of the Bubba system. He's brand new. He just got in. So the whole idea, because remember, Mansfield even asked him that. I mean, they're flagrant about it. He said, you think Bubba's setting you up? Well, they are. You think you're a victim of the Bubba system? Yeah. Well, they brought this guy in and said, well, how can you say that a judge who wasn't even a judge, he was part of the public defender's office, he was defending the guys. All of this was meant to highlight, he's down there in the public defender's office. He's part of defending the people around Ty. How are you going to sit here and say that this guy is part of a conspiracy to put Ty Tucker in prison? And that's why I was worried about it. And then we find out, I don't know how I missed the article, but then we find out that, my God, this guy is as in deep as you could be. He was recommended by Judge Jones. Judge Jones spoke highly of him and said this guy is just in his opinion, is the epitome of what you want as a potential judge. Judge Jones recommended him to Ron DeSantis. And on top of that, this guy says Judge Jones to him represents exactly what a judge should be, and he represents the epitome of serving justice. The same Judge Jones who is and had been leading the cover-up in this case, who had been sealing all the documents, who, again, Ty Tucker was so upset with, he decided to go.
Judge Jones actually swore Judge Morgan in as well. He nominated him for the seat, the judicial seat, and I personally recommended him and swore him in.
Pro se in the first place, who gagged Ty Tucker's wife. This is the same Judge Jones And you know,
welcome
that's
to
a
those
concern.
who just joined the stream.
You know,
Thank
obviously,
you.
this guy is not a friendly, not a friendly at all. He's not a friendly individual. He's not trying to be here to help. He is here to lead Ty Tucker to a prison cell for the rest of his life and finish this cover up. That's what this judge is doing. That's what he's here for. And I think that Flash fan, I believe he will. Yes, I believe that that's coming. I don't have anything confirmed, but I believe that that's coming. Ty and I were talking about that on that broadcast, the last broadcast we had. I think he knows he needs.
If you go to Steve's channel, Justice is a Process, he has another video just prior to this one that was just before Ty was arrested, and Ty was in chat speaking with him, and yeah, they had a big discussion on what was going on. Excuse me, that's what he's referring to. So Justice is a Process. Go and like and subscribe.
Needs help. There's no way in the world Ty Tucker will be able to put the defense on that he wanted to put on from a jail cell with the obstruction, with the ways that they can obstruct his defense, the way they can. Well, Faded, he's in custody. We'll talk about that here. So the reason why he's in custody right now is because on April 10th, he had a alcohol test. He doesn't get drug tested. He gets tested for alcohol to ensure he's not drinking. Why that was put on in this case, I have no idea. This case has nothing to do with alcohol, but he had to go get a alcohol test. He showed up at the alcohol test late because basically the registration at these places only lasts for so long. He had to wait in line, and when he got up to take the test, his registration had expired for the day. So he calls pretrial detention, says, I'm here. I just waited in line. They're not letting me take the test. I need to take the test. Of course, pretrial detention guy says, well, you were late again, Ty. And he says, I know, but I'm here. Let me take the test. So anyways, pretrial detention guy works with the center, and he says, all right, come back tomorrow, but be there early, okay? Be there early. Don't screw around. Get the test done tomorrow, and everything should be okay. So he leaves, and then he comes back the next day. He's late again, okay? So again, take that as you may. He's late again, but he gets to take the test. He takes the test. He passes the test. The judge is notified of this, that he missed the test on the 10th. So unfortunately, if you're going to have a judge who wants to hold you accountable, who wants an excuse to revoke your bond, that's technically, that's technically what, that's technically, I guess, in violation of the terms and conditions. He missed the test, but he's passed the test. I mean, this is the type of situation where I understand, like, I don't know. I feel like there's other ways that this could have been handled, but I think this is what they wanted. This was the message. This is that they want to gag him, and essentially he gets the bond revoked, or he leaves and doesn't realize there's a problem, doesn't know, really anything's happening until he gets notified or called by the other day by his pretrial services guy and says, yeah, the judge has revoked your bond. Well, Jeff, it's simple. It's real simple. I can be in his, because it isn't about telling time. It's about the facts of his case, Jeff. And I've looked at his case, and he's innocent. Okay, whether you like Ty Tucker or not, whether you think, whether you think he's irresponsible, you think he's arrogant. A lot of people didn't like him at trial. When they had him, when they were watching him, at his trial. But the bottom line is, this is a situation where he is a truly innocent guy. He is more innocent than Nikolai Mew. Okay,
Absolutely. And excessive. I mean, this is the new Judge Morgan, not the old one that adjudicated over the first trial in January. The new judge, the protege, so to speak.
he's being set up. And I don't know if you've looked into much of what I've put out on this case, but Ty, if you go to his website, freetytucker.com, it's not even a website, it's a YouTube page. He's got a voluminous amount of materials on that page. And it's clear that he is an innocent man. He's not the most responsible guy, but listen, who is, right? And I'm not saying that he's right in everything he's done. I'm not saying that, obviously he handles things not in the way I would like them to be handled, and not in the way someone should be handling when you're facing a capital charge. But it doesn't change the fact that the state of Florida does not have the evidence in this case. He is a wrongfully accused person. Half Irish. Let's see. What did you say here? He should have focused in the lack of evidence instead of trying to. Well, that's part of the problem with Ty.
Yeah, my opinion on this is because he's a pro se defendant. That's he wanted to do that to have the story told, because it's not an unusual occurrence apparently in Florida for people to be wrongfully accused. And if you actually go back and have a look, there is no evidence against Ty at all. What they have is Travis Johnson's coerced testimony, which he has since recanted, and a photo from Ty's Facebook page, because this happened in November 2017. There was a photo that Ty had posted on his Facebook page of him dressed up in a Halloween costume with a fake plastic knife. And the only reason he became a person of interest was because the following day, they'd identified John Travis Johnson's vehicle, and so he was a person of interest. And the following day, Ty was seen walking with him to, I think, get their phone recharge voucher done. And so the police observed Ty with John Travis Johnson, and then went to his Facebook page, saw this picture, and went, "Oh, he looks like he could have been involved. Let's bring him in for questioning." That's when they detained him. So, yeah. And there was a lot of information that was not allowed to come in through the first trial, as well as the gag order, which they were trying to reinstate again just prior to this arrest. There's a lot of really dodgy stuff going on.
He is so involved in this thing, and this is why you don't represent yourself.
Yeah, what he needs to do, in my opinion, he needs to focus on not proving his innocence, but proving reasonable doubt. Use their own policies and procedures that they didn't follow, their chain of evidence, in their preservation of the evidence, in all of the aspects of the investigation, because internal affairs even became involved in investigating the investigation, and none of that was allowed in either. So if he can focus more on the reasonable doubt, because it's the burden's on the state. They have to prove beyond a reasonable doubt, and without any evidence, they can't do that. It's impossible. So to get where he got as a pro se defendant with a 9-3 not guilty, well, 9 were guilty, 3 not guilty, is a huge achievement, and he has brought attention to the goings on down there by becoming a pro se defendant, which is one of the reasons apparently that he did so. But it's time now that he needs to get back his attorneys back in and nip this in the bud. He's achieved what he needed to achieve. He's got the story out. He's exposed, he can move on and do civil suits after he has proven, well, after he has gotten through this. So, yeah, that's my take.
You're failing to really catch, you know, you fail to make the right arguments. That's why they say, you know, a lawyer who represents himself as a fool for a client and a fool for an attorney, because, I mean, it gives you kind of tunnel vision in the sense that you're on how you're going to conduct your case, because we all know obviously the burden is on the state, and in this case, I truly believe 110%, if Ty Tucker would have had attorneys in that courtroom in January, he would have been walking out of that courtroom not guilty, because there is so much that didn't get to come in that case, that, and we're not even talking about police incompetence. We're talking about the simple fact that there's this. You've got a detective who testified in that trial, and she's been demoted because of her incompetence in this case, her mishandling of evidence.
He's talking about Danielle Malone, and I'm currently going through her testimony from the previous trial at the moment, because I'm doing a deep dive into, I'm trying to work out all the steps of misconduct along the way. So stay tuned.
Destruction of videotapes, key videotapes. On top of that, so, you know, you've got her, who's the one that signs the arrest warrant. She's the one that handled all the investigating. Then on top of that, you've got the only witness that links him to the case, which is John Travis Johnson, whom, if you could have properly impeached him, should have been absolutely destroyed. And Ty did a halfway decent job, but the problem was it was a little bit distracting for the jurors as they're trying to get through his bumbling around with the videos and bumbling around with how to do things and pissing the judge off, and all in all distracting the jury from what they should be focused on, which is this guy isn't telling the truth. So when they get to and then on top of that, he mishandles, the DNA expert ends up getting called, and they act like inconclusive somehow should be used as evidence of guilt, when inconclusive clearly is the definition of reasonable doubt. If something is inconclusive, it breaks for the defense. That was never addressed, because when they go to closing arguments, Mansfield makes a absolutely ridiculous argument that Ty Tucker had no way to know that should have had no way to know that blood on the knife was the victim's, even though he was told that hours before by the captain in an interrogation. But unfortunately, that was allowed to slide in along with pictures that should have never come in, because he testified. And when he testifies, although he did a great job testifying, because he testified, one of the key pieces of evidence, it wasn't even evidence, but one of the key things that the jury said was swaying people to the guilty side was because the state was able to infer that there was a trip based on pictures on Paula Belmont's Facebook page, that there was a trip to California. There was no evidence presented that Lauren Janae or Ty Tucker or anyone had anything to do with that trip to Florida. She was going out to see her family. But the inference was she goes on this trip to Florida and then comes back and gives her proffered testimony, now saying Ty Tucker wasn't at the scene. So anyways, the point is, they make all these arguments, and Ty gets upset and goes and spends his closing argument addressing those. Well, here's the thing, though. That's why, Jeff, I think that what he was trying to accomplish in the first case, or when he first tried the case, was attention to the case. And he wants attention on this because, listen, there are other people down there that have been a victim of these people. You got to remember, there's a prosecutor who was suspended twice for actions and activities related to this case, specifically for trying to, what she ended up being suspended for was trying to stop Ty from marrying his now wife, Lauren Janae, but she was also suspended in another case that involved one of Ty's attorneys, for lying to the court in regards to the use of a confidential or of a jailhouse snitch. Specifically, that was done here where she actually did exactly that in this case. And that was the Raheem Jackson situation, which, again, he's nowhere in this case now at this point because in that situation, he or Colleen Dunn conspired with Detective Pitcher and Penny Phelps to have a snitch, a known jailhouse snitch who was on the payroll of the Monroe County Sheriff's Department, moved into the same wing of the Monroe County Detention Center, and then claimed that Ty confessed to him. Now, this is what's even crazier. Claims he confessed to him, but says that he was put up to the murder by some woman named Lauren. I mean, that's how crazy, that's how horrifying this story was, because this guy didn't even know what the hell the facts of the case were. Lauren, of course, was nowhere near this case prior to Ty getting arrested. Anyways, so they got caught doing that. That's why Ty got bond originally, because, well, all of that stuff, they were going to have a hearing where they were going to put all of that stuff on the record, and that would have sealed Colleen Dunn's fate and probably taken her law license away forever because she'd already done this in another case. So they agreed to give him bond to avoid that hearing. When they avoided that hearing, she got to just simply get suspended again for another year for her actions to try to prevent the wedding between Ty and Lauren Janae. Now, though, let's come back to bite probably Ty in the ass in a way, because guess what? She finishes her suspension, and Dennis Ward just hired her back into the district attorney's office. So she's back. Maybe she'll come back on the case. I mean, that would be the most egregious thing, but she's going to be there in that office helping prepare it, helping to do anything she can to get Ty Tucker convicted. And now they're going to bring him down in cuffs and store him at the detention center. And now this judge is trying very hard to develop at least the public reason why he won't be able to release Ty again on bond. He has a $3.1 million bond, which is akin to no bond, because nobody has $3.1 million to post. You know, well, I listen, Flash fan, if he would have had attorneys in the first trial, I believe it would have been a not guilty. I believe it would have been a not guilty. I believe it would have been, I think you're right. There wouldn't be a need for another trial. But hey, Cam Miller, how you doing, sir? But my thing is, you know, when it comes to Ty, you know, I understand there are people that are frustrated with him. They're frustrated by how he acts. But the bottom line is, at the end of the day, he's an innocent guy, you know, and that's what we have to focus on. That's where the focus has to be. And again, perhaps maybe, you know, you hate to say something like this, but maybe the best place for him right now is to have to go back into detention if it gets him to agree to hire an attorney, because I don't think the outcome would have been any different. Yep. That's exactly right, Jeff. You're 100% right. I believe in that. I believe that. So now do be aware of something else, guys. He has been since offered an Alford plea and the ability to take a no contest plea. Well, Flash fan, that's what I'm wondering. Because it was such a disaster. See, the reason why I'm wondering that is because every hearing we have, since the mistrial, big boy Mansfield has been basically attempting to really paint the picture that the coverage of this trial created a threat to the families of these district attorneys and the state attorney's office, and that they're really worried about their safety. So I could see, yes, a motion coming to say, hey, we're going to try to shut this thing down. And that would be scary as hell. But it could happen. But the only reason why I would see that not happening is because Florida, believe it or not, is one of the states that really holds it. It's very important in Florida for there to be cameras and the ability to see things, and really gag orders are not common in Florida for that reason, because of the sunshine laws, where the courts are supposed to be transparent. You're supposed to be able to see what's going on. So for that reason, I think Judge Morgan may be a little trepidatious, because I think that would really feed into the idea that Ty Tucker is being railroaded here. So I think that I think that would really make people step back. I think that would really get people like Court TV fired up. It might have them come into the case and really start digging into this when they say, well, why are we being kept out? Why aren't we being allowed to see justice as it unfolds in the courtroom? So, yeah. How you doing, Gabby? Nice to see you. And I agree, Sarah, absolutely, 110%. Justice absolutely should be made public. I think it should be something that should be seen, because, listen, there's really nothing more, nothing scarier than somebody who finds themselves entwined in the justice process, because it involves you losing your liberties, losing your rights, losing your freedom, and losing your ability to live. Because and that's the part that I think is, sometimes gets missed, especially when right after this trial and Ty was making appearances and coming out and talking. And it was like I think a lot of times it's like we're on YouTube, we're talking about these things. These people normally are in jail. They're not available to talk or to be right here with us. And here he is with us, but he's facing life. He's facing the rest of his life in prison. And, we've got it. How you doing, Christine? Welcome. And that can't be forgotten, because he truly is. I mean, it's a fight now for, his life. He's going to be in a cell, and again, I understand where Jeff's point's coming. Well, don't be stupid. Don't do dumb things. You're in a fight for your life. Yes, I agree with you. And I agree, he's not the most responsible guy all the time, but that doesn't change the facts of his case. That does not change the fact that everybody should be upset about Ty Tucker's case, not because of Ty Tucker, whether you like him or you hate him, but they should be upset about his case because it could happen to any of us. Any of us. Understand that. What's happening to him is he's being prosecuted with no evidence. This is a guy. This is not a guy. Like a lot of people, I think, oh, well, Ty was in the wrong place. Ty Tucker was staying at and again, a lot of you might not understand the origination of this case. Ty Tucker was staying at basically a converted apartment. Okay. Friends of his had to leave. Now, he was around the homeless people and the drug culture down there. Okay. He was, yes, but he was down there helping a friend. He went into the warehouse where he was staying at because a friend of his had to leave because they had gotten into an altercation with someone else in there who filed a restraining order. So this gentleman had to leave. He didn't have time to move his stuff out. So he said, Ty, would you go stay down there in my room that I was renting until we can get my stuff out? And Ty said, yeah, for the next week I'm off. So I'll go stay there. Sure. I'll stay down there at stay down. It's better than staying at Cots. It's better than, and I'll stay down there at this warehouse. And
yeah, I agree. I completely agree. It must be absolutely petrifying. Petrifying, but watching and listening to Stephen's breakdown, who has gone right over the case with a fine-tooth comb, the jigsaw puzzle starts to fit together. And yes, I agree. Whilst you might not think that, you might not like Ty, you might disagree with his comments in court, the way he behaved or conducted himself, or his timekeeping skills, whatever it is, that still doesn't mean that he's guilty of this. And that's what blows my mind, that it could happen to anybody. And this was, if you go back to the previous video that Stephen put out a couple of days ago, it explains in more detail how massive that decision was for Ty to do that, become a pro se defendant, because he literally put his life on the line to get this story told so that it didn't happen to anybody else. That was originally his main goal, to get the story out there. And this is one of the reasons why I'm following the case so in depth, because I don't believe that things like this should happen in a justice system. Basically, it's there to protect the innocent, and I don't understand how this can happen. I just don't. It blows my mind.
That's what he did. And then he went and paid a phone bill with Rory Wilson. He paid a phone bill. And for no other reason than him paying that phone bill that got him involved in this case, because they were looking for a white guy with a black guy named Detroit, and a confidential, well, it wasn't even a confidential informant. It was just somebody who Matt Pitcher talks to. I believe it was Pitcher that got the information, or maybe it was another officer who told Pitcher, but someone who spoke to the police down there said, listen, there was a white guy with Detroit. And sure enough, what happens? They go down there and they go, oh, holy cow, there's the white guy. And he paid a phone bill. Well, there's our money. There it is.
And she had absolutely nothing to gain. I mean, if she honestly believed that Ty was involved in that and held a knife to her throat and cut, she ended up having, I think, a 7-centimeter cut to her neck. Why would she protect him? Why? It doesn't make any sense. Why would she go to all that trouble, 3 depositions, don't know how many interviews, and then to struggle through that testimony at the last. She was so determined to get through that testimony in that last trial. Why? What did she have to gain? Nothing. And the state are trying to say that Lauren paid her off to go and visit her family in LA or whatever that was for, when there's no evidence to show that at all. It was an inference that the state made in the case to try and persuade the jury to think that she was paid off in some way by Ty. The other thing that they did too with the jailhouse snitch, Liam Jackson, was the autopsy on that was done on Matthew. His name's escaped me now. That's terrible, Jody. The victim, Matthew Bonnet. The autopsy showed that he was stabbed by someone who was left-handed, and Ty is right-handed, and the state had to get around that. So in Liam Jackson's testimony or affidavit or whatever it was they presented, he actually said in there that Ty had confessed to him by saying that he intentionally swapped hands during the altercation to use the knife in his left hand so that he could potentially frame Rory Wilson later down the track. Now, you tell me, if you're in the throes of you've just been sprung by someone in the course of a robbery and your adrenaline's going 10 to the dozen, you have the forethought to go, hang on a second, I'm just going to swap hands with this knife so that they don't think it's me. Really? Really? I'm calling BS on that. Just saying.
Well, no, but Jeff, but the point is that
exactly.
Remember, he did hire a lawyer. He had a lawyer in this case all the way up until September of last year.
They knew of each other, but
but the point is all of a sudden he's there paying a phone bill on a security camera, and this police officer says, oh, that must be our guy, because they go look at his Facebook page and they see that he was at a thing called Fantasy Fest.
Yep. The Halloween.
And
have a look at his Facebook.
It goes from there. And here's the thing. There, if you don't believe me, go to.
Let me see if I can bring up that picture. Or his Facebook page details anyway. Where did I save it? No. Here we go. Oh, come on, mouse work. All right, so that's at the end of this. Come on, keep going. That's the first. All right, so these are the 4 places that you can. Oh, stop. I can't work StreamYard yet, obviously. Anyway, it's free Franklin Tucker on Facebook, but I think that page has been frozen because Lauren can't comment on it. She can't make any updates. And he's got a YouTube page, which is free Franklin Tucker, and he's got Instagram and email as well. And let me get back to Stephen.
His website, go to the interrogation videos, and you can listen to Penny Phelps, Detective Pitcher, Detective Danielle Malone tell you themselves. You can hear exactly how all this develops. You can hear them talk about the Facebook photo. You can hear them talk about the fact that, hey, Ty is our weak link. We're going to bring him in. We're going to break him down, and we're going to get him to confess. And they thought that was their guy. They made a mistake. So they made the decision, okay, we're going to move in. And then they're watching, and they see Rory Wilson, and they see that Rory and his wife, or I guess I don't think she was his wife. I think she may have been his fiance. They see them putting clothes in a bag. They see this bag at the thing. They want to go in and bust it, get a hold of that bag, which ends up having bloody clothes in it. Clothes that don't even fit Ty Tucker, by the way. They're not even his size. But anyways, it's nonetheless, he has they see all of that going on. And then they decide, okay, we're going to make our move. So then that night they go busting in and they arrest Ty Tucker. And they take Rory Wilson into custody. And this is where things go off the rails. Because at this point, Captain Phelps, who has recently been trained under the Reed technique, she considers herself an expert. She steps in and she does what she normally does. She decides to try to get Ty or Rory to turn on each other. And she goes in and determines that, guess what? It looks like Ty isn't going to be willing to turn on him. So she starts working on the girlfriend of Rory and gets her to implicate Ty. And then she moves on and tries to get Rory, who is, if you watch his interrogation video, Rory's like, what the hell are you talking about? I wasn't with Ty. I mean, he looks genuinely surprised. He does not look like, he's like, I wasn't with Ty. Like, he's in shock that Ty's even being brought up in this. He's like, Ty, what are you talking about? Eventually, 3 minutes of tape is missing. And right before it, he says, so you're telling me if I say it's Ty Tucker, I can go home? Tape cuts off. At his trial, he discusses those 3 minutes. And in those 3 minutes, Penny Phelps says, if you don't tell me what I want to hear, here's the decision. It's you and your pregnant wife or fiance or Ty. Okay? Because here's the deal. I'm going to arrest all of you. I'm going to charge her. I'm going to charge you. I'm going to charge her with being an accessory after the fact. I'm going to charge you with the crime, and I'm going to charge Ty. And Ty's going to be the one. Ty's already implicating it. He's saying it's you guys. He's saying, which is a lie. So you know what happens? The tape turns back on, and then he goes and attempts to implicate Ty and tells a totally fabricated story, which if you listen to it, you know it's fabricated, about a Joe and a Mike and a Donnie and a so-and-so that came in, and Ty led this group in to go do this. Here's the problem. They didn't anticipate that all of a sudden, guess what? They were going to get all these videos. They get a video from Tom Thumb. They get a video from Keys Electric. And what does it show? What does it show? Oh, it shows that there's a truck involved. It shows that a truck drives up, parks, and two guys get out of the truck. It shows that John Travis Johnson is the driver of that truck because they see him go into CVS. Where's that video? We didn't see that at the trial. 30 minutes before, John Travis Johnson is inside CVS. His truck is pulled out front. Doesn't appear there's anyone. It appears there's only one other person in that truck. But guess what? All those videos, the only videos that survive, well, we'll get into that in a minute. So they find that. Now they know they got a problem. But what does Penny Phelps say? She says, oh, that's not a problem. That's an opportunity. Because now what we can do is we can implicate all three of them, and Ty Tucker will be our weak point because he's innocent. And now, hey, we can cut a deal with the innocent guy. We're locking him up for a little bit. What's it matter? Whether he's a COTS or he's here, he's a homeless guy, he's a drug addict. It doesn't really matter. To them, they don't see this as anything more than that way they're going to work it like they've done multiple other times. So that's what they turn, and she goes in and she feeds Travis Johnson his story. She decides to get Travis to implicate Ty or whatever, or to see what she can do with Travis, and Travis takes the bait. She feeds him the story. Travis implicates Ty. Now she has either Travis, who can implicate Ty and Rory, or now she can go back, pick up Ty, okay, and see if she can work him. Now, here's the interesting thing. Remember, what was Ty Tucker originally charged with? He was not originally charged with the death, okay? This tells you what their strategy was. See, Ty was originally charged with allegedly threatening Rory Wilson's fiance because they go back to her the next day and she talks to her and says, hey, give me something to pick Ty up on. So they go and pick him up on that because what their plan was, in my opinion, was at that time was like, Ty, here's the deal. You either talk with us, you either agree to help us. Now we got you, and we can even make this even worse for you and charge you with other things. Or you play ball with us and become a witness against Travis and Rory, and we can close this case out and we'll give you the sweetheart deal. But guess what? Ty tells him, fly kite, I ain't talking anymore. I'm done and I want a lawyer. And he lawyers up. So he lawyers up, and then eventually Lauren Janae becomes aware of his situation, and her having been a friend of Ty's from the past connects with Ty, and eventually she decides to bring in real lawyers to this case. And she brings in lawyers. They fire the public defenders and the appointed counsel, and in come the real lawyers, and that blows up everything. And then it becomes, again, just like they said at that interrogation room, hey, oh my God, we better hope that DNA evidence proves that Ty Tucker was present. And then guess what happens? The DNA evidence doesn't. It proves only Rory Wilson was the holder of that knife. And as a result, they go and that was when they decide to attempt to get Naheem Jackson as a confidential informant. Give me one moment, guys. Give me one moment. Traffic Area Task Force that Penny Phelps was the head of. So that's why the task force comes in and says, we got to solve this case, and we got to make sure Anthea Clay doesn't get picked up as a part of it, because she's a huge asset that we need in several cases that she was involved in. So
this is Anthea Clay. Now, it's going back and looking at the first trial and a lot of the videos on Ty's YouTube page of police interviews. Anthea Clay, also known as April, is allegedly a police informant. And there is another theory out there as well that Paula Belmont was an informant as well, and they were working together with the drug task force to set up drug deals and catch dealers, because the treehouse was known as a place of ill repute and where you could purchase illicit substances. And during the trial, I don't know if you remember that there was a $100 bill found at the crime scene, and apparently there was $1,000 of marked bills used during or given to apparently Paula, so that they could be traced back to the dealers when the money was exchanged. And somehow Rory Wilson and John Travis Johnson got wind that there was this money that Paula had, this $1,000, and that's what they were going to her place, to the treehouse, to rob her. That was apparently the motive behind the entire incident. This is one of the conspiracy theories that's going on. But Anathea Clay refused to have her police interview videotaped completely. She there's about half an hour's worth of footage of her going into all sorts of explanations and excuses and stuff with Penny Phelps, but ultimately they turned the cameras and the audio off, and her interview is not recorded. So yeah, there is so many aspects to this case that just have so many unanswered questions, and that's why
As a
I'm
result,
explain.
they hit the scene and they're trying to close this thing out as quickly as possible and button it up and keep this from moving up to Anathea. In other words, they need to discredit these guys who could say, one of them being Rory Wilson. They need to either be working with him or they need him convicted and sent away for life, so he's discredited when he says, well, Anathea Clay is involved in this. And that was the work they were doing. So the idea here was Penny Phelps says, I'm super cop. I'm going to come in and I'm going to shut this thing down. The other thing that we don't know is, remember, John Travis Johnson was picked up about a week before on drug charges. And remember, the drug task force is who's running this thing. We don't know why. And it is uncontrovertible. I've shown the video multiple times. It's on Free Franklin Tucker. 40 minutes after this thing happens, Penny Phelps is in front of the warehouse talking to John Travis Johnson, who is packing up his car, looking like he's trying to get out of town, lies to them multiple times in the conversation, and even tells them there's a black guy named Detroit with a pregnant woman living downstairs, and he tries to say, well, he's not there. I don't think he's there, and tries to get them away. And Penny Phelps does nothing but steers the investigation completely away from all of that. And then, of course, Travis ends up being the one that Penny Phelps is in communication with for the 3 to 4 days afterwards. And he also happens to be at the warehouse the night that Tucker and Wilson are picked up. He talks to Penny Phelps. Then he seems to get a pass throughout this whole thing, and he's the guy ultimately walking with a 5-year sentence, and we know he was involved. We know he drove them there. We know he was most likely, more likely than not, beyond 99.5% certainty based on the evidence, that he was the second guy that we saw walking up the street. We know Todd O'Quinn says, I saw a guy run out, jump in a truck, and get out of there. We know that Todd O'Quinn, the same night that Travis Johnson is confessing all of this, picks Travis out of a lineup and says, I can't say for certain because it was the distance, but that's the closest guy. That looks like that's the guy. His hair, everything. So we know he's involved. Absolutely 110% involved. Ty Tucker was never brought up in any of this. Paula Belmont says he's not involved. So it's a situation where it's a situation where it makes no sense. Now, here's the other thing. Here's a couple of other things that you need to know. and it's proven in the case files. While all this is going on with the confidential informants, Colleen Dunn, the corrupt prosecutor, suspended twice, asks for the codes from Pitcher. This is in Pitcher's deposition. Asks for the codes to access the videos that were on file where she can go in, delete, alter, change, snap up, etc. He gives them to her. They have the messages. He admits it in a deposition. He says, yes, I gave it to her. Never, ever been done before. She had access to all the, a prosecutor should never have access to that evidence. Not that section of it. And what happens? Shortly thereafter, there's a issue, and the Tom Thumb video of where it shows Travis and Ty backing up Travis's or Ty's alibi, showing that he was at Tom Thumb after the crime took place, which would back up the fact that he's what Ty told the police happened, which is that he went to sleep, he woke up, Travis was already back there. He says, hey man, I'm going to walk up to Tom Thumb. Travis says, I'll walk up with you. And they walk up, and this is after Phelps and company and everyone's already come. And he walks up there. That evidence destroyed. Where is the Keys Electric? I want you all to think about this. I want you to think about this. You've got to think about this. This is it. This is the biggest thing. Well, Jeff, he was fed. Have you not seen? I mean, I would say you need to go to the website, and it's absolutely right on tape what happened. You've got to watch his entire interrogation. Okay. It's the most egregious thing ever. There's an expert report, which I have in my possession. I showed it in another live, that an expert on the Reed technique came in and watched it and agrees he was fed. And the story he told did not offer any new evidence. It did not offer anything that, nothing to verify it. And he repeated back the exact same story that she gave him. For 6 minutes, she told him the story. He came back and told it. On top of that, he filed a motion through his attorney saying that story was BS and that he was fed the story. He admitted he was fed, and that was the motion to suppress that Judge Jones kept out of the trial. And had he been confronted with that, because it's a document that was filed in court by his attorney, Seth LeVay, who was going to come in and testify to certify that document was truth. Seth LeVay, as a lawyer, has a requirement that he cannot submit false documentation to a court. So he has to have a basis of truth out of it. And that's what he was going to testify to, that was a basis of truth, and that
wasn't
he
allowed
filed that motion in good faith. When you look at that, in the fact that Travis Johnson certifies in that motion, or claims in that motion, that he was fed the story, that he lied, and that he was pressured by Penny Phelps to implicate Ty Tucker in that interrogation, only to change it when he was offered a 5-year sentence that allowed him to get out of prison within.
So he took the plea deal for the state for time served to 5 years. That was his incentive, and they let him go if he testified against Ty. But if you do go back and watch on Free Franklin Tucker, his YouTube channel, there is a multitude of videos of all different stuff. But if you go and watch the John Travis Johnson interview with Penny Phelps, he's basically you can see his face. He's confused as to what's going on. He doesn't understand what she's hinting at, or what she's getting at, and why she's pushing Ty onto him to blame for the story. And then suddenly there's 3 minutes missing from that interrogation video, and the next thing you know, he's implicating Ty in the robbery. So yeah, I encourage anyone to go and have a look, if you haven't, onto the YouTube page for Free Franklin Tucker. And the other thing is they do have, I might fast forward a little bit here, but yes, Stephen produces this expert on the Reed technique, which is an interrogation technique used by the police to, interrogate suspects and what have you, and they can pretty much tell you whatever they like. And it's a certain way that they interview, and the interrogation tape was shown to this expert, and he did a report on it. Let me see if I can. He does pull it up. Here it is. Let me skip to this bit.
Hey guys, let's share this thing. Oh, I gotta just like
It's very
that. Just when I was about to give up.
Very interesting. But this wasn't allowed to be brought in either.
And Treehouse Docs. All right, here we are.
The gag order was to suppress anything that was to do with witness tampering or
real quick. Expert interrogation,
corruption, or
let's jump into
anything like that.
Full screen. All right. So here it is, guys. This is actually an expert that Ty and his defense team had reviewing this. So we're going to review this individual. We'll review this here. I submit this declaration as an expert in criminal interrogations to inform the court of my credentials and prospective testimony in the above titled case. Personal background and qualifications, just so you understand who this person is. The 2022-2023 academic year marks my 16th year as a professor at Williams College, teaching law-related courses. I graduated magna cum laude and Phi Beta Kappa from Amherst College in 1981 and graduated in 1985 from Yale Law School, where I was editor of the Yale Law Journal. After law school, I was a law clerk for Judge Edward Becker on the United States Court of Appeals for the Third Circuit, followed by 3 years as a senior attorney writer at the Federal Judicial Center in Washington. These are all the publications he's had. My expertise in this area is recognized nationwide. In the 2007 American Bar Association listed my website truthaboutfalseconfessions.com in its top 100 related websites and first among criminal law websites. I am frequently contacted by media and attorneys seeking consultation. I've been formally retained as an expert consultant in more than 250 cases and have testified in 42. He's been qualified in Florida, Alaska, Arizona, Colorado, Connecticut, Florida, Georgia, Indiana, Kentucky, Massachusetts, Montana, New Hampshire, New York, North Carolina, Ohio, South Carolina, Vermont, Virginia. You see all of them here. So he gets into the background about false confessions here and says that there have been documented cases of people who confessed to crimes that they did not commit. In the 1990s, social scientists and legal scholars began undertaking studies and developing an extensive literature advancing understanding of interrogations and confessions. This work has been conterminous with another crucial development, in large part due to DNA testing. The surprising prevalence of false confessions has been established. DNA testing, I want you to understand, DNA testing in this case is here, right? We have a state attorney who knows DNA testing has exonerated Ty Tucker. This expert is saying if you have DNA and you have a false confession, go with the DNA. The DNA has exonerated close to 400 persons convicted of crimes. More than 1/4 had confessed. Spurred by this discovery, reformers redoubled efforts to identify false confessions. Many hundreds of proven false confessions have been documented, and virtually everyone acquainted with this area recognizes that these cases represent only a sliver of the cases of false confessions. Interrogation methods widely utilized by law enforcement significantly contribute to false confessions. The basic approach is often referred to as the Reed technique because Reed and Associates has produced the most influential interrogations manual and training programs. The literature referenced in footnote 1 documents and explains the correlation between this method and false confessions. Confrontation and minimization are at the heart of the Reed technique. Confrontation involves interrogators expressing certainty of the suspect's guilt and aggressively thwarting his denials, as well as confronting the suspect with evidence, often exaggerated or fabricated, allegedly establishing his guilt. Minimization involves introducing themes accident, provocation, justification, secondary role. That's what they use. That's what Penny Phelps was using against the people she tried to use it in this case, that explicitly or implicitly reduce the severity of the crime or the suspect's culpability. Confrontation communicates to the suspect the futility of maintaining innocence, whereas minimization implies that confessing will avert serious punishment. Accordingly, confrontation frightens the suspect and brings on despair. Minimization supplies a lifeline, especially when used together. They have been shown to break down innocent as well as guilty suspects. Awareness that the Reid technique contributes to false confessions is not limited to the academy. In 2017, one of the leading schools of interrogation, Wicklander and Zulawski, announced that on the account of Reid technique's tendency to produce false confessions, they will no longer train interrogators in this method of interrogation. While the literature primarily deals with false confessions, the Reid technique also contributes to false confessions. Indeed, false confessions often accompany false confessions. The suspect acknowledges participation in a crime while assigning greater culpability to an accomplice. Moreover, there is reason to believe that people interviewed about potential crimes by others may be even more susceptible to making false statements than suspects interrogated about their own possible wrongdoing. A confession or accusation is most reliable when generative, and this is the important fact that everybody needs to understand with this. If it generates new evidence previously unknown to law enforcement, it is least reliable when it contradicts known facts about the crime. Apply that to this case and what you know of John Travis Johnson's confession. It generated no new evidence. It contradicted facts about the case. Application to the present case. He's going to go ahead and discuss that right here. I was retained by attorney Jerome Bellarato to assess the interrogation of John Travis Johnson and Mr. Johnson's accusation of homicide against Mr. Ballarato's client, Franklin Tyrone Tucker. To make this assessment, I have relied primarily on the videotaped interrogations of Mr. Johnson. I've also reviewed Mr. Johnson's motion to suppress his statements at his own trial and discussed the case with Mr. Bellarato. So I want you to understand that motion to suppress is very important. During the interrogation of Mr. Johnson, Captain Penny Phelps aggressively engaged in the Reid technique. Captain Phelps expressed certainty that Johnson was involved in the crime. A plan to rob the victim hatched, according to Phelps, by Johnson, Rory Wilson, and Tucker that went awry and resulted in the victim's death. Captain Phelps claimed falsely to have proof of Mr. Johnson's involvement. We have your truck on video, you, Rory, and Ty all on video. This was standard Reid technique confrontation. Captain Phelps I'll
come back. There is no there's only two people that are seen on that video coming out of John Travis Johnson's truck. Two assailants going in and one coming out. Not three, two. Thank you for popping in, Reverend Beasy. It was lovely to chat with you, and thank you again. And I look forward to hearing from you again. Have a good night. Oh.
Who got jammed up in a bad thing. These are common minimization themes.
Sorry, Stephen.
Captain Phelps urged Mr. Johnson to place blame for the crime on Mr. Tucker, the asshole in the story, who broke bad and killed the victim. Johnson eventually adopted Phelps' version of events wholesale. His accusation and concomitant confession was non-generative, merely telling Captain Phelps what she claimed to already know. And to my knowledge, Mr. Johnson's version of events is contradicted by scientific evidence and eyewitness testimony. Significantly, Mr. Johnson himself has described how the Reed technique broke him down and produced a false account from him. His motion to suppress his confession at his trial states as follows. Captain Phelps not only lied to Mr. Johnson about video surveillance, which did not exist, but also the former captain repeatedly lied to Mr. Johnson regarding statements made by witnesses as other suspects, which were never made, in order to incentivize John Travis Johnson into making a false confession. Mr. Johnson subsequently recanted this recantation, but as part of a plea agreement that ended his incarceration. Applying my knowledge of criminal interrogations as described in paragraphs above to the facts of this case described in paragraph, I can say with certainty that Mr. Johnson's accusation of Mr. Tucker came after he was exposed to the interrogation tactics known to contribute false confessions and false accusations. Moreover, his accusation did not generate new evidence and is contradicted by independent evidence. Accordingly, in my opinion, there is no substantial reason to question the reliability. There is substantial reason to question the reliability of Mr. Johnson's accusation of Mr. Tucker. So,
there you go.
With that said, guys, that's from an expert. Okay, that's from an expert on interrogation who reviewed this case, the evidence in this case. So let's see here. What's my friend Jeff saying up here? Getting every cards with him. He played dominoes with him, but he was drinking Fireball and smoking weed. He was not doing crack. Okay. So we'll see if he ends up appearing or not. We're not certain on that 110% if he'll be there Monday or Tuesday. And I think he's also looking into, and I think he was going to look into anyways because he was going back to jail. We were talking the other night. He's also look forward to the potential possibility that his attorneys re-enter the case at this point for the simple fact that he needs the help. He's got a pretty complicated situation ahead of him now. Let's see here, Louisa. Okay, so you're saying GG. Great, thanks. GG.
I think Lauren comes into the
Let's
chat
see here. I'm
very
missing some
shortly.
comments here. Let me take a look here. Okay, first of all, yeah, Louisa, a couple of things to understand. Ty was not smoking crack that night, well, by his own testimony. Maybe he was, but he says, John Travis Johnson now says he was, but remember, Luisa, you have to understand, he wasn't a resident of that place. So, yes, he was not a crackhead. See, this is the part a lot of people don't understand. They just hear that he was staying there. He was not a resident of that place. They were not his friends. He was staying there temporarily to help out a friend. That is established. That is a proven fact. He was there to help out another gentleman who had gotten a restraining order that didn't allow him to be around someone in that place. When that person returned, he had to leave. He reached out to Ty, and Ty was going to be off for a few days from work. He said, Ty, I've got to leave, but I can't, I have nowhere to put my stuff. We're getting a hotel. I have a whole bunch of stuff in this apartment. I've got to move it all out, but I don't want these people here that are living there. There's a bunch of crackheads. There's a bunch of people that are living there who will steal your stuff. So I don't want that to happen. Can you come stay here for a few days until I can get my stuff out? That's what happened. So he goes there to stay there for a few days. Very unfortunate decision for Ty Tucker. But that's why he was there. He was not an associate. So he was there playing cards with him. He played dominoes with him. But he was drinking Fireball and smoking weed. He was not doing crack. Okay? That's not true. Now, those guys were. Other people in that house were. Right? That's what they were after. But he was just kind of there. And that's why everybody said Ty was the guy that would be like counseling the young bucks. Hey, man, don't do that. That's going to get you in trouble. And then, but he wasn't going to stop them from doing it. That was his role. And again, I'm not making this up. Go on his website that he put up all of the discovery videos, and you can see police statements from people that were in that house giving statements about who Ty Tucker was, what his role was in that house. And you also see the fact Ty Tucker was never implicated at all until Penny Phelps implicated him and suggested that he was involved. But even if he was smoking crack, it doesn't necessarily mean that he was going to go do this. So that alone shouldn't even be considered. But I'm just saying we can also say that isn't even a factor. But yes, even if he was, it doesn't necessarily that should not just mean, hey, he was doing that.
It's not an admission of guilt by any means.
What is he making up, Louisa? What's he making up? Because what he said is backed up by evidence and corroboration. I didn't just believe him. He said, check out this, check out that. I went into the court case. I'm not relying, the things I've went and, the things I've went and saw did not all come from Ty Tucker's website. I went into, like anyone can, go to the Monroe County Clerk's office. You can go back for 7 years. There's a wealth of documents. There's a wealth of documentation. There's transcripts.
I think there's a high probability of him obtaining legal representation now on his behalf because he can't defend himself whilst he's incarcerated. So I'm hoping that they can establish probable doubt. But yeah, if he continues to go pro se, I don't know what the outcome will be, unfortunately.
There's
Don't know.
depositions. There's police reports. There's incident reports. There's police statements all on that site now, all open for public dissemination because the gag order got lifted.
I think that's why they've arrested him now. To shut him up.
And well, yeah, DG, the other thing is, I mean, you lose your teeth if you're homeless, so you don't have a dental plan and you're out there on the street, and you're drinking and you're not brushing your teeth. I mean, yeah. I mean, but yeah, I mean, that's what I'm saying. I don't, Ty has it. Ty, I think maybe doesn't communicate things as clearly as well. He says something and it doesn't always come across the way he wants to because he's trying to communicate. Like
the problem with that is he's got to preserve the record and be able to make the objections in order to preserve that record so that he can appeal it. And at this stage, he hasn't managed to do that from the previous trial. So that's where having legal representation comes in extremely handy because they know where to make the objections and they know how to put things on the record so that they can appeal it. Because I don't think he stands a very good chance of getting granted an appeal based on the first trial because of his inability or lack of knowledge on how to preserve that record.
Like he's got all this stuff in his head and he throws it out there and it just doesn't come across right because you haven't seen all the documents.
Yes,
which is one of the reasons why, I've been talking with Ty about, he and I had talked multiple times about him coming up on the channel, but I felt it important that I needed to get, and I waited too long, obviously, but I wanted to get certain things out. I wanted to have stuff out for my viewership that would put a base of information out so that instead of him trying to tell you these things, we already have seen it. And well, Louisa, what paperwork have you read? And if you're talking, and if by watching the case you mean watch just the trial, that is not enough. You've got to go in and read and watch. You've got to go watch the actual police interrogations. Full, no greater proof of how weak this case is when a pro se defendant, who is clearly a bit disorganized, who didn't have all his ducks in a row, and he's able to come in and get a 9-3 mistrial.
She establishes a few facts.
Now, that's also why I tried to tell Ty, that's the evidence you need right there to say, get a lawyer involved, because if you have an organized lawyer and an organized defense who's cross-examining witnesses and putting forth the suppression motion.
Right.
But see what Jeff had to say. I said Ty wants attention more than his freedom. Well, I think the way
I love Bruce Rivers. He's my idol. I love him. If you've seen him in my intro video, he cracks me up. He's so funny. Bruce Rivers, he's a criminal lawyer, but what'd he do? It's another awesome. If you haven't seen it, CLR Bruce Rivers, criminal. Oh, is it CLR Bruce Rivers? Yeah. Can't remember what it stands for, but yeah, he's hysterical. Absolutely hysterical.
Ty views it though, Jeff, is it's about, Ty's aware of other cases too that have been affected and other people that are sitting down there in Florida prisons who were affected by these dirty guys. And
that song's going to be
so
in
I
my
think
head.
in his mind, it was like if he can help bring attention to this, it can help others that are down there. But really, honestly, like I tried to talk to him about it and was talking to him about it the other night. Win this case, and then everything else follows. But just win the case. You don't have to prove innocence. Just prove that they can't prove their case beyond a reasonable doubt.
Yeah, probable doubt. Probable doubt. Come on, show Lauren's comment. I'm running out of cashews.
Good. Well, that's excellent news, Lauren, because I think it would be very difficult for him to be able to manage his defense from behind bars. I really do. I think it would be a tremendous undertaking that.
Whilst on that subject, I'll take these off because I can't read without them. Lauren's Facebook update today on Ty. Thank you all for your continued support of Ty during this difficult and unexpected turn of events. Ty remains in Portland, Oregon, and is currently being held in Multnomah County Detention Center. He has maintained routine contact with me. He's in good health and is as determined as ever to continue the fight to prove his innocence. We are expecting Ty to appear before a judge here in Oregon any day now, and we will report the outcome of that hearing as soon as that happens. We are working to obtain all the information we can and pass it along to the public as soon as possible. Updates on this case will continue. Stay tuned. Now, it's my belief that Stephen has the link. I've tried to look for it. He has the link to the Portland courthouse for the hearing. I can't find any calendar on any of the courthouses down there with a link to a stream. So I've actually emailed Justice is a Process to see if we can perhaps do that stream together. Fingers crossed. That would be really good.
Just very well probably would give the state a chance to convict them with the BS that they're going to pull and the way they can argue to the jury and put things before the jury in a way, and then distract Ty in his closing argument. I mean, and Ty's not going to be in any mental state, being in jail all the time, to be ready for trial.
Bruce Rivers is a criminal lawyer. But what did he do?
I feel like if it's Ty now, since he's locked up, he needs a lawyer now more than ever. He can't fight it when he's locked up. Hire a lawyer, hopefully a good one, and he'll win the case. Yep. Now, Lauren, there was a suggestion from someone earlier that on a lawyer, and it was a good suggestion. I don't know if this lawyer would even consider it, but he was the lawyer for the Travis Rudolph case. He's a Florida lawyer, so he would be in the state. He just wouldn't be part of that area. But I think the best lawyers, though, guys, in my opinion, would be the lawyers he had before, because they know the case. This judge isn't going to give a new lawyer any amount of time. They're not going to. He's already made it clear he's not going to continue the case further. Ty created the situation by firing his attorneys. So this guy's not going to go, well, we're going to continue the case for 120 days. He's going to say to the new lawyer, you better be prepared on trial date at this time. And if that lawyer doesn't feel that they can adequately represent him, and we watched this in the boy in a box case, the mother, the judge did it to an attorney that was in there, and the judge just said, well, then I have to withdraw. Now that immediately, in her case, she hasn't agreed to go pro se, so that immediately threw the case back kind of into a tailspin. But that's what the judge can do and say, well, show up. Now, in Ty's case, because he's willing to go pro se, he'll probably show up and try to try it pro se. Mark Shiner. That's it, T.S. Jackson. Thank you. Well, the problem with that, Flash Fan 85, or bringing in anyone out of state, is they're not going to like it. First of all, they're not going to really be up on Florida law, because they're not licensed in Florida. They're going to have to get local counsel. And they're not very friendly down there to getting people that are out of town, let alone out of state.
The two lawyers that he had were put up by, they weren't public defenders. They were funded and put up by Lauren. So they're not like, it's not like they were terrible lawyers at all. Not that a public defender is a terrible lawyer, but yeah, he was getting good representation, but the reason he chose to go pro se was to get the story told, basically, to get it out there that this could happen to anybody. But he's achieved that. He's obtained that goal. There is no reason now to be pro se. He needs to get his ass out of there, basically, and then pursue whatever it is he needs to pursue on a civil level and not a criminal level. Get your ass out of jail first. Get yourself exonerated. Prove that you're innocent. Well, prove reasonable doubt, basically. That's all he has to do. You don't have to prove that you're innocent. If you can't, they've got to prove that you're guilty. And then go for it. He's trying to package it all in one because he's so emotionally involved in it. He's thinking that, well, I'm innocent. I can't lose. But when you're fighting the system, or the apparent system that's down there, then unfortunately you can. And you pay the ultimate price. That's right. He can't help himself or others if he's inside.
So what he needs, he doesn't need Mark Geragos. He doesn't need Johnny Cochran if he was still alive. He doesn't need some amazing
this guy's awesome
lawyer to come in here. He just needs a lawyer who is competent, who knows how to argue, and he can beat this case, because this is a very weak case. And he also, but he also needs a lawyer that's willing to stand up to the judge and willing to stand up and willing to advocate for him without excuse, without concern, without worried about their reputation or having to come back and face these judges and prosecutors again and worrying about ruffling their feathers. They got to be willing to go in there and kick ass and take names and piss them off and do whatever they need to do.
Yeah.
I didn't see the judge show any emotion regarding the verdict. I think you're biased. I thought Judge Jones bent over backwards in this case.
Really?
Sarah says Peter Traeger is his father. Well, I understand a lot of people have been reaching out to Peter.
I actually watched that the judge when the verdict was read, and it's almost like like he's just gone, oh, fuck. Really? Of course he was pissed off.
Peter is a personal injury lawyer. He'll say that on his channel. And his father is the defense attorney, but I don't know that his dad would probably, again, you got to remember too, some of these guys have cases and schedules and trials coming up. And again, this judge is not going to be amenable to a lawyer coming in and saying, hey, I'm taking over the case, but I can't try the case until May of next year.
Yeah.
They're not going to do it.
Not going to happen.
Oh, good. Oh, Shiner is. Oh, that's awesome news, T.S. Jackson. That's great, because I'll tell you what, I was not impressed with Tim Faraday's attorneys at all. So I hope she's got a shot then, and she needed to bring in a heavy hitter like that. I'm glad he's involved. He's a really good attorney. I really, really was impressed with him with Travis Rudolph. He reminded me a lot of my dad. And I really liked him. I remember watching with my dad and my dad and I were watching him together. He's a really good attorney. He really is.
So Cara and
well, there it
Jerry
is. And that's the thing. That's what we
previous
need.
attorneys.
Lauren, and that's what I'm saying. They know the case inside and out. They've been fighting this thing for years. They're the best fit for this case. And unless the only reason why, Lauren, I think everybody was a little bit concerned about them was because Ty led everyone to believe the other night that they were going to charge $200,000 for the trial, which everyone unanimously thought is insanity. And that he said that was obviously too expensive. So the idea, I think, kind of flew up. There's got to be others that are out there that would be willing to take on this case and do it. Well, absolutely. And I think Ty acknowledged that his lack of having like a staff or a paralegal or an assistant or someone that could do the things that a fully staffed legal firm can do for you definitely hurt him. Well, he could direct you to someone, right? But the point is, though, under your scars, is there is someone here. So Peter is not going to direct, anyone to direct them to anybody that is going to charge less or do less than what the attorneys that he had. So that's why they need to come back in unless they're unavailable or unwilling. And then that would be a situation where they could do that.
Going in and out of my
Oh, I agree with you, T.S. Jackson. Tim Faraday's attorneys were terrible. I don't know where he got those guys from. I was so unimpressed. I reposted that trial up and rewatched it again, and it was as bad the second time I watched it as it was the first time. It's really, really bad. And I was not surprised he got convicted. I was only surprised it took him. It didn't. I thought it would have been quicker. And then that man, not to say that he doesn't maybe deserve to go to prison based on what he did in that case, but I felt like the attorneys in that case were not very competent, in my opinion. It was not a good defense. It was not good work at all. Oh, that number was thrown out there at one point. Okay. Well, I think, like I said, I think they gotta, if they're talking about 200,000, I mean, come on, they got to get real. That's not happens. And then I guess he never did anything with it next. So Lauren, did he just not follow up with it? Did he never took and kind of would come in and get a small fee to come in and act on your behalf just to give you your rights and say, okay, do you want to waive extradition or not? If he waives extradition, it's easy. And then Florida has like 30 days to pick him up. And if they don't pick him up, he gets released. How you doing, Kylie? Yes. Brief recap. Ty got picked up essentially for he had alcohol testing, mandatory alcohol testing on the 10th of April. He showed up late, waited in line. Because he was late, his registration expired. At that time, he attempted to contact pretrial services. Pretrial services reached out to the facility, arranged it so he could come back the next day. They told him to be back like first thing next day to do it. He showed up late for that, unfortunately. But he did take the test. He passed the test. But the judge, because he missed it on the 10th,
wait for it.
I guess decided that, and again, technically that was out of compliance. The judge went ahead and signed an arrest warrant for him being out of compliance based on him missing on the 10th. Even though he says he didn't miss it, but he was late, his registration expired anyways. That's why the judge did it. And then, he did not take the test. Oh, he did not. Okay, Lauren has given us an update. Okay, I told everyone time me, and I still been thinking he took the test. Oh, so he didn't take the test. So he told everybody that he did take the test. He was compliant. Now I'm understanding. Okay. So then he shows up late the second day. All right, guys. So he shows up late the second day.
Mm-hmm.
Same thing happens. And then I guess he never did anything with it next. So Lauren, did he just not follow up with it? He never took the test, or did he take a test at a later date that was in compliance? Well, yeah, unfortunately, Sarah, it does. If you don't take the test, they have to consider that you're messing around and playing games.
And then he decides that he's going to do the right thing in his own mind and surrender himself in the Florida Keys. But he forgets he's got the ankle monitor on. He doesn't follow the process of alerting anyone that he's leaving the confinement of his house arrest to travel on an aircraft out of the country. And subsequently, as soon as that ankle monitor detects that he has left his confinement, it alerts and sets off a what's it called? A fugitive alert. So they pick him up at the airport. So it's just a unfortunate progression of some poor timekeeping, basically, and unfortunate decisions, which has landed him back where he is. So anyway, I think that's probably enough of Steve. But please do head over to, I'll put his information up again on his site, because he's a wealth of knowledge, and he will be live streaming, as I said, the hearing that Ty will appear in front of the judge in Oregon. But as he said, they can only hold him for 30 days in Oregon because he's not, the charges are in Florida, so they legally can't keep him any longer than that. So this is, justice is a process. Let me take out my, there we go. You can support his channel because it's not monetized with a Cash App, or buy me a coffee, or ko-fi.com /justice is a process. And that is his Facebook page logo, not Facebook, YouTube channel logo. So now the other thing that I wanted to update everyone on too, so we've done Darrell Brooks. He took a plea deal, and his sentencing hearing is either June or August 17th. I'll have to double check on that, but that was for charges relating to allegedly running over his ex-girlfriend, Erica Patterson, and the injuries caused in that injury just weeks before the Walk Ashore parade, and intimidating a victim, witness intimidation, and bail jumping. So he took a plea deal on those 3 charges, and I think they dropped the 3rd bail jumping charge as part of the deal. So Darrell Brooks has been sorted. We'll keep you up to date on Ty Tucker, and I've been emailing Lauren, so hopefully she can update me if I miss the live stream with Stephen. And wish them all the best, basically. I will keep you updated as much as I can. And I've been, I'm going to extend the invitation to Lauren to see if she wants to come on to the channel just to have a chat and update everyone. I can't promise anything, but I'm doing my best to get that to happen. And the other thing that I need to update everyone on is the Chad Dolman case. Apparently they've been granted a continuance. The trial was supposed to begin in July of this year. And yeah, they've been granted a continuance until I think the end of January in 2025. So that one's been put on the back burner for now. But there's a couple of trials coming up that, whilst horrific, I'm going to investigate. Actually, Judge Boyd is starting one today, the 7th of May. And there's another one starting on the 17th of May that I'm looking into as well. But at the same time, I'm doing a deep dive on all of the aspects of Ty Tucker's case that are so-called dodgy. And I'm going to try and put up a presentation and a video just to piece it all together so that it's not so bitsy. So thank you very much for joining me again on another live stream. I shall be back in the next couple of days, no doubt. Hopefully you're not sick of my face by then. And enjoy my new little outro creation that I played with today. Thank you for joining me, and until next time, I bid you adieu.
Coverage true crime and police arrest, where the judges move and the defense rests. Watching courts and trials, criminals at best, where the gavel drops and the defense rests.